you like to make a statement? At this point in time, we'll each make a statement and then deliberate publicly what our findings are.
Well, as I'm sitting here listening to both sides of this, I can see that Mr. McIntyre has...
Speak into the mic. Yeah, thank you.
...has been operating under a lot of misconceptions. One of them is that he thinks that the county clerk or the city clerk has any obligation to provide them legal information on file a petition or an objection. We do not. We are advised by attorneys not to give that information out if we even happen to know it. Now, I happen to know a lot about the candidate process, but I know nothing about abolishing a home rule public question because in the 31 years since I started working here, this has never come up. So I definitely would not be able to give anybody that information because I don't know. As to your question about an attorney, I find that a little unusual in that I have to ask attorneys frequently to interpret the law for me, and you're correct, I've never had one tell me that they couldn't get the answer because the attorneys usually read the law book and come up with the answer for you. Or at least the attorneys I've dealt with over the years, this one and previous city attorneys, have always done that for me. I think it's unfortunate when the citizens of DeKalb signed a petition not clearly understanding what they were signing, because you yourself have said in contradictory statements, did you want this to go to the city council for them to act on it, or did you want it to go on the ballot for a referendum? You told me one thing in writing, you've said a different thing today. It's unfortunate because when you passed out that petition to the people, you didn't have the information they needed, or you didn't have the right information. It's too bad that you didn't understand in election law there are different requirements for different types of elections. You yourself referred to one when you talked about another process on a waterway or something only requiring 500 signatures. That should be an indication right there that there are different requirements for different types of petitions. And I'm sorry, I think you interpreted the law wrong on this one. And regardless of our feelings, my feelings at least, on the issue, my personal feelings, I have to follow the law. And it looks pretty plain to me right now what the law is on this, that it should have been 10% of the registered voters in the whole city, not just on those who choose to vote.
Thank you, Ms. Johnson. Ms. Gorski?
I think it's, as far as a referendum to be at the next election, I think I feel badly and fortunate for the people that signed this petition. And people that signed it are in no way indicating whether they're going to vote for it or against it. They are signing to get it on the petition. And I feel bad that what may be the spirit of their wanting this public discussion at the next election did not have sufficient numbers of signatures to meet the requirements in the statute. Elected officials are asked at the very beginning to swear an oath to uphold and support and defend the Constitution. And statute as written and read and certified by the county clerk was specific, and there are not enough signatures in order for us to consider the petition for the referendum to be complete and to be put on the ballot. So I would have to believe that the objection is valid.
Thank you, Ms. Gorski. I too feel it's unfortunate that the work was put into it by the petitioners to get individuals to come forward with their wish to have this placed on the ballot. I I was not approached. One of the defendant's arguments was that he's approached the city council. I was never approached by anyone. I don't know whether any of the other city council members were approached to have this placed for discussion on a city council agenda. In fact, if I remember correctly, at least the way I understood it, I may have misunderstood it, Mr. McIntyre, you stood in these chambers and said the petition has been signed, and now the voters will have an opportunity to vote in the election of November 7th. I may or may not have heard that correctly, so I'm not making that as a statement, but that was a recollection. You made a statement that the burden of proof is placed upon the objectors, and that is the case. In this particular case, I think the burden of proof has been proven through the testimony of Sharon Holmes and the affidavit that she presented. This is not about whether or not home rule should be on the ballot. This is not related to any personal feelings that I may or may not have related to home rule. I, as Donna stated, am obligated to hear the case and make a non-biased judgment based on the evidence that's been presented. And I have to determine whether I personally believe that the state laws regarding to this petition have been met, and I don't believe that they have, according to the testimony that I've heard from the objectors. So I also would uphold the objectors in this particular and unfortunately say that the petition is not valid at this time to be placed on the election for April 7th. Yes.
Is there a motion on the status of the objection?
Do I hear a motion on the status of the objection?
I will move to uphold the objection and not place the public question on the ballot.
Is there a second for that?
Second.
Any other further discussion? All those in favor signify by saying aye.
Aye.
Opposed, same sign. The objection is upheld. Now, I want to do say, Mr. McIntyre, you do have a right to appeal to this. We will make a written statement regarding this particular finding, probably within,
An hour?
before the day is over. And you do have 10 days in order to appeal this to the Circuit Court for DeKalb County. At this point in time, I will close this hearing. Declaring this hearing is closed.
On behalf of the objectors, I just like to say thank you, and I think this is the kind of process that really protects everyone's rights. Thank you very much.
Is there a question?